Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to Our Curious Amalgam, the podcast from the Antitrust Law section of the American Bar Association. My name is Matthew Hall, and today's program is What's Next for EU Competition Policy? The European Commission's Competition Policy Review. There's a lot going on in the EU competition or antitrust law world at the moment, as we sit here or record in the first quarter of 2022. The policymakers and enforcers in Brussels, in other words, the European Commission, have been working on a very wide range of policy documents, guidance materials, and new legislation. At the same time, there is pressure to adjust competition law to make sure that it supports, or at least doesn't get in the way of, wider EU policy goals, in particular the EU's key policies of the green transition and the digital transition. The current list of initiatives is so long, I count nearly 30, that it's very difficult to keep up. A lot of this is technical or seems technical, but nevertheless will shape policy for a long time. It's important to understand what is going on, and that's what we will try to do today. My co-host today is Jaclyn Phillips. Jaclyn, who is our guest today, and what are we going to talk about?
We're very excited to have Claire Jeffs with us today to talk through the European Commission's November 2021 communication regarding the future of competition policy. Claire is a partner at Slaughter & May, based out of London and Brussels, and she is co-chair of Slaughter & May's competition group globally. And Claire, given your vast experience with EU competition law, we can't wait to hear your views on the ins and outs of this new communication and what it means for competition in the EU going forward.
Well, thanks, Jaclyn. Thank you, Matthew. It's great to be here.
I think to start off, do you think you can give us an overview of just what this communication is and what it's saying? And in this communication, is the EC telling stakeholders and businesses that it's, doing anything new?
Yeah, great question. This is a policy communication, which DG Competition were effectively asked to do by the new Commission President when she came into office. And I think what's interesting about it is it gives a kind of overview of many ongoing competition policy and enforcement initiatives. Many of which were ongoing as kind of ordinary business, but it really puts them in a political context, in a way almost like a historical context of how these kind of competition policy initiatives can contribute to Europe's recovery from the COVID-19 pandemic and to the key EU policies about the green transition and the digital transition. And, these are such important issues, and it's really fascinating to talk about competition policy against that backdrop. As I was kind of alluding to, a lot of this isn't really substantively new stuff. It's stuff that was going on already, and it's really all about making sure that the European competition policy instruments in merger control, in antitrust enforcement, and in that very European thing, state aid control, are all fit for purpose in the current environment.
Yeah, that's great. And I noticed that you said this is somewhat historical because, one of my questions, especially being a US-based attorney, is this something common? What is kind of the context that we're seeing this new communication? And it sounds like this is a really interesting time to hear the EC talk about competition policy within the broader context of all these things going on in the world.
Yeah, absolutely. And they're, reviewing a bunch of guidelines and other competition instruments. There are a couple of legislative reforms that are ongoing as well that they've drawn into this overview. So one is the new Digital Markets Act, which they call the DMA, which is currently going through the European legislative process and will introduce a new regulatory framework for large digital platforms, a bit like some of the legislative discussions that are going on in the US. So that is now going to come through later this year. So, that's a part of this as well. And then there's also a new proposed foreign subsidies regulation, which again is a legislative instrument aimed to address distortive effects of foreign subsidies in Europe. So, there's a whole bunch of stuff going on here that feeds into this kind of broader overview.
Yeah. So, in practice, it sounds like there's these reviews going on, but there are it sounds like a lot of unknowns for, what the future might hold when all this is kind of done.
Yeah, well, I think one of the points the Commission, I think, rightly make in the communication is, these are, the fundamental laws, European antitrust law, go back to the early days of the Treaty of Rome and the founding fathers, Article 101, 102, as they now are, long-standing, of course, merger control is more recent. So it's long-standing concepts, but then what is so important is how they are flexed and adapted to deal with challenges as they arise. And, that is really important. And I think that's what we're talking about here.
Yeah, absolutely. And that's fascinating. And I'm excited to kind of jump into all, the competition tools and hear about what the EC is saying about each one of them in the context of what's going on in the world today. So there's a lot of information packed in these 20 pages. So let's take it piece by piece. Turning to merger control first, does the communication give any hints as to what we can expect from the EC there?
Yeah. So, basically merger control, it's nothing radical. But they do refer to a number of kind of significant developments in the policies. So the first thing is the Commission has committed to updating the market definition notice, which, some of you may be surprised to hear that dates back to 1997. That's even before my time. So it's really old. So certainly it's timely to look at that again. And the Commission in particular are looking at the impact of the internet and on markets and the way we now do business in an increasingly globalized way. The other main development they refer to is what's called the new guidance on the application of Article 22 of the EU merger regulation. Article 22 is the provision that allows member states to refer cases up to Brussels, to the Commission. And under the new guidance, the Commission are encouraging member states to refer problematic transactions, even where they're below the relevant national merger thresholds, which is a change in policy that the Commission announced last year. And the objective is to get at the concern that is, expressed about what some people like to call killer acquisitions. Acquisitions of small but highly innovative companies, could be in the digital space, could be in the pharmaceutical space, and to get those cases before the European Commission. So through that route. So this, highly significant, quite controversial, and important policy change. So that's something they talk about. And also in the DMA, this new digital regulation that is coming in later this year, there will be a provision allowing the EC to require major digital platforms to provide information about their acquisitions so that they can monitor those. Those I think are the really points. Merger control perspective. More broadly, and I think rightly, what they do say is, look, merger control is a really important policy instrument for making sure our economy works well, and that there is effective competition and choice, and input access to inputs is not foreclosed. So I think they rightly said, just normal merger policy is helpful in dealing with the challenges we face as a society. and is really fit for purpose. So, I'd say incremental change only. There's been quite some debate in Europe since the Siemens Alstom case, with some governments saying, look, merger policy needs to kind of be more sympathetic to the need to create European champions to face global competition. But I think the Commission have been quite resistant to that concept and, really believe that it's effective competition that we as a society need. But I think perhaps the revision of the market definition notice, and specifically the treatment of geographic market definition, is a bit of a kind of flex to say, we are looking at global impacts. But, I don't think it's going to be radical change.
There's a lot there and a lot to unpack. So, we kind of brought it back to the market definition notice. And, can you just tell us a little bit about how is that notice used? And, I noticed that the communication talks about, like you just said, market definition being very fact specific. It's a case by case inquiry, the importance of geographic market. So how do you think that, this update, whatever comes of it, will in practice impact, merger review? And I'd imagine antitrust more generally as well.
Yeah, that's right. It's not just relevant to merger control. I mean, obviously, once the notice is updated, the Commission and, parties and advisors will refer to that in their decisions and submissions. So it will have a kind of soft influence in that way. I must say, I think that's one of the guidelines that we refer to relatively little at the moment, probably because it is so old. So hopefully the updating process will make it just more relevant to current practice. But I think, they've said that evidence from market participants will still be key. And clearly it's a case-by-case analysis, right? So, we'll see how that plays out.
Yeah, that makes total sense. And the 1997 date definitely struck me as I was looking at this. It says, now's the time, and it's 25 years ago. So there might be a bit there to be updated. I know you mentioned that this is really incremental, and what are your kind of general takeaways as to what the communication says about merger and about merger control, what that means for merging parties in the EC going forward? Do we see any kind of concessions that the EC is making regarding, the importance of helping to develop, strong European companies?
I don't think there are any significant concessions. I think probably in practice, the most significant thing is the change to the Article 22 policy. So we may see more smaller deals being looked at by the European Commission. And certainly, that's been attracting a lot of comment and interest in some quite high profile cases this year. So I think that will probably be the main impact on the merger side.
Jaclyn, I know you want to move on to other parts of the document, but just to advertise, we have one of our other podcasts has actually looked at the Article 22 issue in a lot of detail. So for those who are interested in that pretty controversial issue, we refer you back to that other podcast.
Thanks, Matthew. Yeah, that's great. It sounds like there's a lot there about that important issue for, to get a handle on. So I'm glad there's more there for our listeners. And you're right. I there's a lot more in here. So I guess let's get to it. This sounds like a good place to go to the antitrust rules. So in your view, what are some key takeaways regarding the Commission's approach to antitrust enforcement that we're seeing in this communication?
Yeah, so again, on the antitrust enforcement side, they kind of do a recap of everything that's gone on in that space. So as you'll know, the European Commission is in the middle of revising its vertical agreements, block exemption and guidelines. And that's really aimed at addressing, how online distribution is changing the way that firms do business and allowing those guidelines to catch up with some of the really key current issues coming out of the case law about parity clauses and so on. So that will be a refresh of the vertical guidelines. And similarly, in the communication, they refer to the fact that there is upcoming a review of the key horizontal guidelines. And again, the European Commission will be looking at those in light of kind of the digital environment we all now live in. They say they're going to try to provide updated guidance on data sharing, and in what circumstances that is permissible and doesn't undermine competition. They also say that they're going to provide more guidance on cooperation with respect to sustainable products or production processes. That's obviously really important for the green deal agenda. And the Commission they said this already, but they reiterate it here, that they are willing to provide guidance to help companies work out where coordination to achieve sustainability goals is okay, because the benefit outweigh any restriction of competition. And similarly, also in terms of the digital transition. So again, trying to just move existing guidelines and case law forward in the current environment. But I think, again, on the antitrust side, one of the things you get from this communication is, of course, the European Commission referred to the fact they're already very active in enforcement in some of these sectors. So they refer to their cartel case with respect to car emissions technology as relevant to the green agenda. And then on the digital side, they refer to the many well-known enforcement cases that the European Commission has taken in that sector, including, for instance, the Google shopping case. So, again, they're saying we're flexing, we're updating, but also we think our tools are fit for purpose, and we're absolutely, applying them to achieve policy goals around the green and digital transition. And then finally, of course, in this area, they refer back to the point I touched on earlier about the Digital Markets Act, and that the new regulation in the digital space will really kind of work in tandem, hand in hand with competition enforcement in individual cases.
Claire, I'm interested in your thoughts on the guidelines or the guidance, or the addition to the guidelines on sustainability. There's been a lot of discussion in the EU, of course, on how far you can push the existing law. I think the Dutch authority has kind of taken a wider approach to some of these issues of benefits. Do you see the Commission taking playing a straight bat here, or do you see it trying to push things further than we might expect? Do you think we're going to be disappointed, in other words, when these sustainability guidelines or guidance comes out?
Well, I suspect, they tend to do a good job of drafting, guidelines in a way that, leaves quite a lot open, shall we say, for individual application in individual cases. I mean, I think one thing that was good this year, and the refer here, willingness potentially to give guidance in individual cases. I don't suppose there'll be many of those cases, because obviously it's quite a resource-intensive thing to give that sort of guidance. But I think that would be welcome, because back in the day, you used to get negative clearance decisions, individual exemptions, and then that all went away with modernisation. And it does mean you end up with this slightly unfortunate situation that you've only got negative decisions, where people have been found to have breached the law, but you don't really get positive decisions saying where the commission think a particular practice was okay. And so, individual guidance in individual cases that are politically important for sustainability reasons, I think, could be helpful just in terms of shaping expectations about what is the right side of the line.
That's really interesting. And I think, I noticed through the communication, a focus on joint forces for, R&D efforts and jointly making products, even, as seen necessary due to the pandemic and all of that. So it's interesting to see all of these, current real life things coming into play in competition policy. And I think with that, the final part of this is state aid that I think we should talk to. So here, have you speak to. So could you just give us a little background, a little bit of a primer on kind of what state aid is and how it factors into the EC's efforts to achieve, competition policy objectives and what we see in this document on state aid?
Sure. So, state aid is a whole kind of subtopic within European antitrust law, which, goes back to the beginning and really sets out rules trying to prevent distortions of markets and normal competitive forces as a result of individual governments or states giving public funds to individual companies on a selective basis. So it's, really at the heart of the internal market and European competition policy.
Yeah, that's a helpful bit of info for those of us not in the EU. And what's the EC saying about, state aid in terms of, its competition review and the future of competition here?
Yeah. So obviously the kind of whole thing is that in certain circumstances, state aid is allowed. And so they talk about a number of new initiatives. So one is that there are new guidelines on climate aid, if I can put it like that were adopted in January this year, so that is aid which supports the decarbonisation of industry in Europe in line with the net zero Green Deal objectives. So they'll facilitate support European industry to achieve cleaner transport, energy efficiency, and broadly a cleaner and more circular economy. So that's the first thing. It's really obviously getting at the green transition. The other thing they talk about in the communication is the prolongation until June of the pandemic state aid temporary framework. So this, allows targeted support to businesses hit by the pandemic, and they're now extending it for another 6 months to gradually withdraw that sort of aid, but at the same time ensure that, businesses who continue to be affected don't go over the cliff edge, right, as aid is withdrawn. So, they have a plan now for withdrawing that. Also say that they're going to evaluate how that has all worked and, learn lessons about how to deal with these sorts of events from a state aid policy perspective.
I think the last thing was an amendment of the state aid framework.
Yeah, so there are a couple of new tools coming in as part of the state aid framework. So the first thing is a tool to create incentives for private investment to kickstart the economy, for instance, by upgrading digital infrastructure or increasing energy efficiency. And then the second new tool is about strengthening the solvency of particularly smaller companies who have been adversely affected by the pandemic. So again, it's a refresh to deal with, current challenges and ensure that Europe is kind of as fit as it can be for the future. And then the final thing they referred to is just the existing program for Europe-wide support for projects of common European interest, which is, really strategic in industries like hydrogen, clean hydrogen, or battery technology, these technological areas that are really key for our collective future.
Yeah, I mean, I think it's kind of fascinating to see how competition law is evolving to take, the green transition into account and the pandemic, and we see it, through all of these tools within this document. And I think, it seems like the takeaway from this is we'll just be kind of seeing how this evolves going forward, and how this adaptability and flexibility comes out in practice.
Absolutely. I mean, I think it's all about the kind of point we were discussing at the beginning, that the most of this is long-standing areas of law, really kind of key tenet of European competition law, but flexing it and developing it through this kind of review to ensure that it's really, really fit for the future.
Yeah. And I mean, I think you've pretty much summed it up, but what are your thoughts on what companies can kind of draw from this, and what to take away from these ongoing reviews, going forward?
Yeah, I mean, I think probably the key thing is the obvious. Competition policy is still absolutely at the heart of the European Commission's broader political agenda. And I guess for those of us who are, spending a lot of our time working on competition law and policy, that's a heartening thing that, this practice area and this area of law does have an important role in our economy. So, I think that reinforces that companies need to be careful to pay enough attention to competition enforcement. I guess we all know and agree with that. But, as we've been saying all along, I don't think this is in any way radical change. It's evolution, definitely not revolution.
Claire, that's been a great canter through a very wide range of topics. So thank you very much for that. I'd like to shift gear now to our final section. You're, as Jaclyn mentioned, you're a partner at a large law firm. And we'd be interested to know what your advice would be, if you could help us with that, to your 20-year-old self who's interested in who would still be interested in your career path or career. Do you have any particular thoughts or comments or warnings that you might give to her?
Right. Well, that's a big question, but I think what I would say is, be yourself, enjoy your work, and make it part of your life. I hope, actually, maybe I've managed to convey today that, competition law is something that's very exciting to me. It's very meaningful to me. And I think, that's what makes a career worthwhile. If you can really make it part of your life and part of yourself.
I think you have conveyed that. Clearly, it does come out. And finally, we ask all our guests this question. Could you please tell us something interesting or unusual about yourself that we wouldn't know from just your professional work?
Yeah. Well, I wish I could come up with something, amazingly glamorous, but I thought, hand on heart, what I ought to say is that I'm a very proud mother of 2 teenage boys who are busy revising for their mock school exams this year. And in fact, one of them has just tried to come in probably with a question about their vision. So it's not that unusual, but I did just want to mention them.
Well, it's good that you've got them doing their revision. That's a harder thing than some of us struggle with that, that's for sure. And you can now go off and help them with whatever that subject was. So thank you very much for joining us.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.